The requirement that prosecutors disclose exculpatory and impeachment evidence under Brady v. Maryland, 1963, and Giglio v. United States, 1972, has given rise to one of the most contentious and constitutionally significant tools in the criminal legal system, the Brady List. Known by various names, Brady List, Giglio List, Do Not Call List, or Disclosure List, these rosters identify law enforcement officers whose credibility has been compromised, often due to documented dishonesty, misconduct, or sustained disciplinary actions that bear on their ability to testify truthfully. Brady lists have evolved from informal prosecutorial notes to formalized systems with legal, ethical, and operational implications. They reflect an acknowledgement that the integrity of the justice system cannot be separated from the reliability of those who serve as its frontline witnesses. Yet, as simple as the principal soundtrack and disclosed known credibility issues, the implementation of Brady lists is anything but uniform. Across jurisdictions, practices vary wildly. Some prosecutors maintain detailed, publicly accessible databases. Others deny that such lists exist at all. Some law enforcement agencies fully cooperate in identifying Brady material officers. Others obstruct, conceal, or even retaliate against those attempting to flag misconduct. This chapter will explore how Brady lists function in practice. It will examine their administrative mechanisms, legal foundations, operational uses, and the broader implications they have for prosecutors, defense attorneys, police departments, and public trust. We will also address some of the unresolved challenges that surround these lists, questions of fairness, transparency, privacy, and reform. Ultimately, we argue that while Brady lists are imperfect, they are essential. Without them, the obligation of truthfulness is left to hope and habit, rather than structured enforcement. What is a Brady list? A Brady list is a roster maintained typically by a prosecuting agency of law enforcement officers whose credibility is sufficiently in question that their involvement in a case requires disclosure to the defense. Officers may be placed on a Brady list for various reasons. Documented instances of dishonesty, e.g., falsifying reports, lying under oath, criminal charges or convictions, sustained internal affairs, findings related to truthfulness or misconduct, allegations of coercion, abuse, or bias, evidence of misconduct that undermines reliability as a witness. These lists are not databases of guilt or criminality. They are risk management tools for prosecutors. Their purpose is to ensure that defense attorneys are informed of any potential impeachment material, in compliance with Brady and Giglio. Importantly, inclusion on a Brady list does not necessarily imply the officer has committed a crime or even violated a departmental rule, only that there exists evidence which may be materially relevant to the defense. In some jurisdictions, prosecutors use a tiered system, distinguishing between officers who are currently under investigation, officers with past but unresolved credibility concerns, and officers who have been formally disqualified from testifying. In others, the list may simply be a spreadsheet with names and internal notes. The criteria for inclusion are not always public or consistent, which leads to both operational confusion and legal conflict. Who maintains the list? Responsibility for maintaining Brady lists generally falls to the prosecuting agency, such as a district attorney's office or state attorney general. However, collaboration with law enforcement agencies is essential, as prosecutors often rely on police departments to flag officers with relevant disciplinary records. This relationship creates several complications. Prosecutor-controlled lists. When prosecutors independently maintain the list, they typically draw from sources such as internal affairs summaries, civilian complaints, personnel records, when accessible, judicial findings in prior cases, notifications from police leadership. Some prosecutors proactively review law enforcement personnel files, conduct regular audits, and create disclosure units specifically to track Brady material. Others operate in a reactive mode, only updating the list when issues arise in litigation or media reports. Police department resistance. Law enforcement agencies often resist full cooperation with Brady list compilation. Reasons vary: fear of reputational damage, concern over civil liability, pressure from police unions, or a belief that internal discipline should not affect legal proceedings. Some departments deny prosecutors access to personnel records entirely, invoking privacy laws or collective bargaining agreements. This resistance can severely limit the accuracy of Brady lists. In jurisdictions without subpoena power or mandatory reporting laws, prosecutors may have little ability to verify or update their records. As a result, officers who should be flagged may remain unlisted, while the defense remains unaware of critical credibility concerns. How are officers placed on the list? There is no national standard governing how officers are selected for inclusion on Brady lists. Criteria and procedures vary by jurisdiction, but some common mechanisms include sustained internal investigations. When an officer is found by internal affairs to have committed misconduct, particularly lying, falsifying reports, or excessive use of force, prosecutors are often notified and may review the findings for disclosure implications. Judicial findings. Judges occasionally make formal credibility determinations in written opinions. If a court finds that an officer testified falsely or withheld information, prosecutors typically flag the officer for inclusion on the list. Prosecutorial determination. In some cases, prosecutors independently determine that an officer is not credible based on patterns in their testimony, inconsistencies in reports, or prior incidents. These decisions are discretionary and may or may not involve formal review. Defense-led challenges. Defense attorneys often surface issues of officer credibility through cross-examination or motions practice. These challenges may prompt prosecutors to review records and update the Brady list accordingly. While some offices offer due process mechanisms for officers to challenge their inclusion, e.g., hearings, appeals, many do not. This leads to criticisms that Brady lists lack procedural fairness, especially when inclusion results in diminished career opportunities or public exposure. What happens once an officer is listed? The consequences of being listed vary depending on the jurisdiction and the extent of the officer's credibility issues. Disclosure obligations. The most immediate consequence is the legal requirement that the prosecution disclose the officer's status to the defense in any case where the officer is a material witness. This may include sharing the underlying misconduct record, a summary of findings, or other impeachment material. Failure to disclose can lead to suppression of evidence, dismissal of charges, post-conviction relief, prosecutorial sanctions, civil rights lawsuits. In this way, the Brady list serves as a protective mechanism not just for defendants, but for the integrity of the prosecution itself. Employment implications. Officers who are deemed giglio impaired, that is, incapable of testifying without impeachment, may become functionally unemployable in investigative roles. Police departments may reassign them to desk duty, administrative roles, or non-law enforcement positions. In some cases, departments will terminate employment or accept resignations in lieu of firing. Public exposure. In jurisdictions where Brady lists are public, inclusion can lead to media scrutiny, reputational damage, and community backlash. While transparency is essential for accountability, it also raises questions about privacy, due process, and the potential for misinterpretation or misuse of information. Legal and ethical challenges. The Brady list system, while essential, is riddled with legal and ethical tensions. These include due process for officers. Critics argue that being placed on a Brady list can amount to an administrative punishment without proper procedural safeguards. Officers may be listed based on allegations rather than sustained findings, or without an opportunity to contest the facts. This raises concerns under the 14th Amendment's guarantee of due process and may conflict with collective bargaining protections. Prosecutorial discretion. Prosecutors wield enormous discretion in compiling and using Brady lists. Without clear criteria or transparency, this discretion can be abused or inconsistently applied. An officer in one jurisdiction may be listed for a minor infraction, while another may escape scrutiny despite more serious misconduct. This inconsistency can have wide-ranging consequences for defendants and for equal protection under the law. Conflict between unions and oversight. Police unions often contest the creation or expansion of Brady lists, arguing that such systems circumvent disciplinary appeals and unjustly harm members. In some cities, union contracts prevent departments from sharing disciplinary findings with prosecutors unless compelled by subpoena. These provisions act as structural shields against accountability and compromise the public's right to a fair trial. Reforming and strengthening the system. Improving the efficacy and fairness of Brady lists requires a multi-pronged strategy. Standardized criteria. A national or state-level standard for inclusion would enhance consistency and reduce the perception of arbitrariness. Criteria could include sustained findings of dishonesty, criminal convictions, judicial credibility rulings, pattern complaints or lawsuits. Clear standards would help ensure that inclusion is based on material relevance, not prosecutorial whim. Independent oversight. Brady lists should be subject to independent review, either through inspector general offices, civilian oversight boards, or judicial panels. This ensures that listings are credible, fair, and defensible. Oversight also reduces the risk of retaliation or political misuse. Transparency with safeguards. Public access to Brady lists increases accountability, but must be balanced against privacy concerns. Redacted summaries, anonymized data, or tiered disclosures may be appropriate in some contexts. What matters most is that the public understands how the list works, why it matters, and how officers are held to account. Integration with decertification systems. States should integrate Brady listings into their officer licensing and decertification processes. An officer who is unfit to testify should not be permitted to move to another jurisdiction and continue policing. A centralized reporting system would prevent the wandering officer phenomenon and close the loopholes that currently undermine reform. Conclusion. The mechanics of Brady lists may appear administrative, but their implications strike at the heart of due process, public safety, and institutional legitimacy. They are both a mirror and a measure reflecting the reliability of the criminal justice system, while also serving as a metric of its ethical discipline. A well-maintained, transparent, and fairly enforced Brady list is one of the few tools available to ensure that law enforcement officers who have failed in their duty of truth do not continue to wield unchecked power in courtrooms. In the chapters that follow, we will examine how these lists impact prosecution and defense strategy, the consequences of non-disclosure, and the evolving debate around their reform. For now, it is clear, the integrity of our justice system depends not just on the truth, but on the systems we build to protect it. I am a dedicated author and researcher specializing in the intricate nexus of technology, law, and government. My extensive body of work includes a diverse array of books, scholarly articles, and policy papers that delve into the evolving challenges and opportunities presented by technological advancements within legal and governmental contexts. Through rigorous analysis and insightful exploration, I examine how emerging technologies such as artificial intelligence, cybersecurity, data privacy, and blockchain shape and are shaped by legislative frameworks, regulatory practices, and public policy initiatives. My publications aim to bridge the gap between technical innovation and legal governance, providing comprehensive resources for policymakers, legal professionals, technologists, and academics alike. By addressing critical issues like digital rights, cyber law, technology-driven governance, and the ethical implications of technological integration, my work contributes to the development of informed and adaptive legal systems capable of responding to rapid technological change. I am committed to fostering a deeper understanding of how technology influences governmental operations and legal standards, and vice versa, thereby promoting the creation of robust, equitable, and forward-thinking policies. In addition to my writing, I actively engage with government agencies, legal institutions, and technology firms to offer expertise and collaborate on initiatives that ensure the responsible and effective implementation of technology in public spheres. My dedication to exploring and elucidating the intersections of technology, law, and government underscores my commitment to advancing knowledge and facilitating informed decision-making in an increasingly digitalized world.